Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3064, United States of America versus David M. Long, also known as Damo Appellant. Mr. Talai for the appellant, Mr. Hobel for the appellate.
Mr. Talai.
Good morning, and may it please the court. Andrew Talai on behalf of defendant and appellant, David M. Long. I'd like to reserve 2 minutes for rebuttal. I'd like to start with 2 brief updates for the court, and then I'll turn to the interpretation issue, followed by the district court's clearly erroneous dangerousness finding.
Are these updates beyond the 28J letters?
Yes, Your Honor.
Okay.
Just yesterday, the Fifth Circuit Court of Appeals held in a case called Shikambi, which is available at 2021 Westlaw 129-169, in a published opinion that sentencing guidelines section 1B1.13 does not apply to defendant filed motions. This is in addition to the 10th Circuit's decision in McGee, which was in our 28J letter, and now brings the tally up to 6 courts of appeals that have held in published opinions that 1B1.13 does not apply under the plain language. Now, the second issue I'd just like to raise briefly is an update to the statistics that were provided in our brief. I think this is important just because it underlines the uniqueness of the current age we're living in. There have been 3,247 grants of sentence reductions or compassionate release applications since the First Step Act. In addition, due to COVID-19, 20 inmates at the Springfield facility where Mr. Long is located have died. That's 8.69% of all deaths in the federal system, and it's the highest number of any federal prison.
Mr. Talai, you're 2 minutes into just 10 minutes, so let me ask you something. You just said that all these courts have decided 1B1.13 does not apply. That seems pretty self-evident. But counsel in the district court, was that you, Mr. Talai, said USSG section 1B1.13 applies to motions for reduction of sentences filed pursuant to 18 USC C1A. Right?
Yes, Your Honor, that was not me.
You put the wrong law in front of the judge. You realize that later on. Is that fair enough?
Well, no, Your Honor, that is an accurate assessment of the proceedings, but just to be clear, that was not my firm. We were appointed as pro bono appellate counsel by this court.
Well, that's good. So
yes.
Is it not the case? You just counsel put the wrong law in front of the judge, got a judgment based on the wrong law.
Well, so this goes, Your Honor, this goes to the government's argument of invited error. And for 2 reasons, I think at most what we can say here is that sentencing counsel acquiesced in the error, but he didn't waive the issue, and Mr. Long is not prohibited.
I wouldn't suggest it's waived. Well, maybe I would, but my point is this. We're in a bit of a box, it seems to me, or bind, I guess I should say. Now there are some cases that say, well, if it wasn't really strategic, and obviously it wasn't, then it's just a mistake, not an invited error. If we go down the mistake route, our review is for plain error, right? And well, I think aside from the difficulty of saying the judge made a plain error under the circumstances we've just agreed occurred, plain error would require, I believe I've got this right, that this would show a reasonable probability that but for the error, the outcome of the proceeding would have been different. All true?
Well, even I believe Mr. Long would prevail even under the plain error standard, Your Honor. And the standard is reasonable likelihood, and that comes from this court's decision in Sorrow. And just to put it in context, that's not the same standard as cause and prejudice in the habeas context. And it's not even really the same standard that applies to a Strickland claim. It's something less than that. So this court has explained in Sorrow that the interest in finality is lessened in the sentencing context. The same was said in Molina-Martinez by the US Supreme Court.
It's from Melina Martinez that I quoted to say a reasonable probability. You said reasonable likelihood. I think they're the same. So we know the judge's view on dangerousness, right? And if he goes through the exercise that would, based on the correct law, dangerousness would be a factor, correct?
Well, not under the guidelines, Your Honor. The interest in protecting the public.
Under 3553, is that wrong?
Well, it's a different standard, Your Honor. They go to similar concepts. Under the 3553A factors, the standard is they need to protect the public from future crimes. Under the guidelines, it's a somewhat different standard that comes from the pretrial detention statute. So they're not actually the same standard. But in any event, Mr. Long would argue that there was a significant procedural error in this case. So it's yes, the district court clearly erred in finding dangerousness, but the district court also applied the wrong standard entirely.
Wait a minute. Erred in finding dangerousness? We've been discussing the law rather than the facts here, right? Until just now when you said that.
Yes,
you mean erred in even talking about dangerousness or something like that?
Well, I wouldn't say erred in just talking about it, but I would say that there are two bases for finding, that the error here was not harmless. So the first being a legal matter, procedural matter, and the second being a substantive matter, determination on the merits was incorrect.
Well, if it was a mistake, right? We'd have to find that his substantial rights were infringed, correct?
Yes, Your Honor. And I think
so. If we do that, will the district judge not be looking at? He already assumed compelling circumstances when he made the ruling. Now, so if we go back and he says, I either assume or I actually find compelling circumstances, but also says in the proper terms for 3553, essentially what he has said about dangerousness to the community. We're not going anywhere, right? Or Mr. Long, I guess, is not going anywhere.
No, Your Honor, I don't think that's correct. And part of the reason is that the district court, in the hypothetical we're thinking about here, I think it would be an abuse of discretion if the district court were applying the correct standard. So assuming that 1B 1.13 did not apply, and rather than considering all of the 3553A factors and balancing them, the court simply said, well, I think there's a dangerousness problem here, and gave no further reasons. That would be an abuse of discretion.
The same judge dealt with Long's co-defendant, correct? And 4 months later in another compassionate release case.
Yes, Your Honor. And
actually distinguished the Long situation while he was applying the correct law in the co-defendant's case.
I don't know if it was exactly correct, but it was a much better analysis, and I think it's certainly worth a read. A very thorough and thoughtful opinion. Although I think the distinctions that the district court made with respect to Mr. Long's case fall flat.
So, Mr. Talai, I gather you're making a separate, clearly erroneous argument about the determination of dangerousness, and I understand your legal point that it was packaged wrong because it was following as if the guideline applied, assuming that we get past the invited error obstacle and we're looking at this. Tell us about your more record-based, clearly erroneous analysis. You hinted that it had in part to do with that the district judge did not do the full 3553 balancing. So lead us through your factual analysis.
Yes, Your Honor. I just wanted to note that I've crossed into my rebuttal time.
Okay, go ahead.
Thank you, Your Honor. So yes, we have a separate factual-based argument. I think the two things to focus on are the clear disparities in the outcomes here between Mr. Long and Mr. Douglas. Their similarities are remarkable, from the underlying conditions to the underlying crimes to the extremely severe criminal history, even to the length of the sentence that they had served, 41% in both cases with respect to the Morrissey murder. The clean record, disciplinary record, the pursuit of rehabilitative programs and education, the ties to a law-abiding family in the community and a support network. And these are all things that the district court simply ignored in its order. It ignored the role, for example, of the probation office in ensuring that Mr. Long, stays out of trouble. It ignored that the risk of recidivism reduces with defendant's age. It actually clearly erred, and I don't think there's really a dispute here in respect to assessing Mr. Long's coursework. And as I mentioned, a lot of that was designed towards rehabilitation. I mean, he took a class on how to learn Excel. He was taking writing courses. It's very clear if the evidence was correctly assessed, it would have painted a different picture of Mr. Long's efforts to rehabilitate over 10 years in prison. In addition, we would argue that the district court gave short shrift to the lack of disciplinary violations.
Can I ask, I'm sorry, are you done, Judge Pillard? Are you done, Judge Pillard?
Yeah, I'm finished.
You're done? Okay. I just had, sorry, did you have a question, Doug? Go ahead. I had one, but you go ahead. Nope. All right. On the plain error standard, the substantial rights prong, because the district court felt compelled to address the dangerousness finding, felt required to do that. He never got to exercising his sort of balancing discretion under 3553. So the discretionary judgment that you say should have applied here, given the assumption of extraordinary and compelling circumstances, was never made. Do you have a good case for the proposition that the failure to afford a defendant, or here a prisoner, an exercise of discretion required by law is itself a deprivation of substantial rights? Or do we have to sort of prognosticate how we think that that discretionary exercise would come out when the district court never did it in the first place?
Right. Well, so thank you, Your Honor. The first thing I would mention is in Molina-Martinez, which is an analogous context and did involve plain error. The Supreme Court said that where the district court is silent or the record is silent, it's very hard to determine whether there was, prejudice or not. And in that case, the court did seem to indicate that there would have been a deprivation of substantial rights. In addition, I would point, Your Honor, to this court's cases in Smith and White, which were not in the context of plain error, but in both circumstances, the court explained that a failure to consider all of the 3553A factors as relevant was a clear abuse of discretion and remanded for the district court to conduct that inquiry. And I think even in Molina-Martinez, the Supreme Court explained that, where the record is silent, there's always an option for a limited remand for the district court to conduct the analysis in the first instance. So to the extent the court is concerned about that issue, the availability to send it back to the district court is there. And I don't think it would, in addition, I don't think it would undermine the interest in finality, because again, we're not even in the context of a resentencing, a plenary resentencing. We're in the context of a sentence modification proceeding, which the Supreme Court in Dillon explained is an exception to the general rule of finality.
Do my colleagues have any more questions?
Thank you.
All right.
Thank you
very much, Mr. Talai. We'll have from the government now.
Thank you. Mark Hobel for the United States. David Long is a danger to the community. At the age of 34, he paid tens of thousands of dollars to have 3 men killed in a murder for hire scheme to further his drug trafficking enterprise. His co-defendant, Reginald Douglas, didn't do that. And this is on top of the kidnapping and murder of Anthony Morrissey 17 years before.
Can I ask you about your invited error argument?
Mm-hmm.
It strikes me as a little unusual. Usually invited error isn't just, one sentence in the standard section of a brief. That usually means someone has advocated to the court and argued to the court for adopting a proposition. You can put aside this strategic factor, but you see affirmative argument, an effort to persuade the court to adopt a position, which the government did in this case as to the dangerousness finding. But Long's counsel did not. There was sort of that one background standard reference and then never mentioned again. What is your best case for the proposition that something like that, where there's no argument to the district court, is just laid out as a background in this, that it's relevant, it's a standard, legal standard in the case, but then there's no argument of that standard supports an invited error ruling?
Right. So I think Driscoll and jury instructions and requesting a statement of law, but I recognize that
I'm sorry. So,
the
but in jury instructions cases, there's usually some argument about this is what the right jury instruction should be, and we think you should adopt it.
right. And
There's
this is
nothing
all
like that in this brief.
right. And this is all on the papers. And I understand we, invited error asked the court to just consider this waived. And if the court's not inclined to do that, we've made our argument about
I'm asking
that.
I'm asking you your argument. And it's just, it's an unusual one for me to see the government, when itself was the one that actually affirmatively argued for the standard, to sort of hoist it as an invited error on the defendant. So I thought for sure the government would have had sort of some kind of on-point case to support that.
That's correct. I mean, I think we're analogizing this to jury instructions, and there was some strategic advantage in being able to say point to the sentencing guidelines and the statement and say my medical condition, is an extraordinary and compelling reason. That's right there. But I recognize there was an extensive argument on this, and the government, of course, did make arguments on both this policy statement and the 3553A factors. I think if you look at the government's brief, it's all kind of rolled in together there. But on the substantial rights prong of plain error review, what Mr. Long has to show is that if there was a legal error here, and there's an absolutely clear legal error here, he has to show that this had some reasonable likelihood that this impacted the substantive outcome. It's not enough.
I just want to be crystal clear. You agree that there was plain error here in applying this guideline?
I don't agree. I realize that
I misunderstood what you said.
In the sense of error that was plain without the other factors, it was clearly wrong as a legal matter.
No. We don't agree.
I thought you said that too.
I thought he said that.
No. I'm sorry if I we don't agree with that. We realize that we've gone. It sounds like I wasn't aware of the Fifth Circuit case, but it sounds like we've gone 0 and 6 in other circuits on the legal argument here.
I mean, what could even be the argument that it's not wrong?
Right. Well, we've made the argument in our brief, and I'd say I think it's from a plain error perspective. The issue here really is what difference does this make as a
right? But that's not the error that is plain. That's substantial rights, and that's where I thought you were focusing. That's why I thought you went right over whether it was actually wrong, because it does seem, in a case in which it affects substantial rights, I can't really see the point that it's not wrong.
Right. I think this case could be decided. I think the district court should be affirmed on the third and fourth prongs of plain error review. I think that's stronger for the government, certainly here, which is why I'm focusing on it. But we don't agree that there was absolutely clear legal error, but we realize that those are arguments that courts have not accepted. And I'm prepared to answer questions about that. But from the government's perspective, the issue here is it really plain error for a district court to look at a defendant like Mr. Long, who's committed 2 murders, 2 attempted murders, find that he is a danger to the community right now, that if he was compassionately released right now, he would pose a danger to the community, and deny that? Is that plain error? When the district court could have and would have made the same determination under the 3553A factors.
Well, that's where Mr. Talai is, I think, maybe on his strongest ground in saying, why should we second guess the discretion in all the factors of the 3553 inquiry when the district judge, for understandable reasons, didn't even go there?
Right.
So what's your response on that?
That the district court essentially did what 3553A requires it to do. It balanced the factors, the mitigating factors that David Long put in front of the court: his physical condition, his record.
I think he discussed those in terms, but only in terms of that didn't dissipate his sense of his dangerousness determination. But it seems pretty common in the court when a district court judge makes a ruling. Let's assume, for purposes of this question, that we decide it was plain error. And that ruling is, I have no discretion, I must address this. And if I find this, I have no discretion to balance anything else, because that's what the old guideline provided. And so we never got around to exercising that discretion. Do you have a case where the court has said, well, we'll decide how we think that the exercise of discretion would have gone?
Right. So I think that the closest analogized case that I could find, and unfortunately we did not cite this in our brief, so I'm happy to. It's United States v. Mack, 841 F3rd 514 from this court, and that was a case where at sentencing, there was a sentence manipulation argument that the defendant had made in its briefs. In his briefs, the district court did not address it. The defense counsel did not object at sentencing, and this court found there was no plain error in this procedural issue of not addressing this argument, because in an earlier motion to dismiss on kind of entrapment grounds, the district court had denied that motion to dismiss and the indictment. And the court said, it's basically the same argument. It's basically the same analysis, just presented at a different procedural stage. That's not plain error because he hasn't shown that.
That's fair. Okay, now I understand that point. But that's why my question here is it the same question when you think you have no discretion and when you do have discretion? And I thought normally, because I think you agree with the standard of review being abuse of discretion review here. And if they didn't ever exercise that discretion in the way that the law entitled Mr. Long to have it exercised, I'm not sure that is the same thing.
Right.
It's not that he couldn't come to the same result. There's
right.
The record is what it is, and it'll get balanced the way it gets balanced. But I'm more concerned about the absence from the district court of any balancing or discretionary judgment that the law seems to entitle.
Sure. So two responses to that. First, it's a procedural right to have that balancing done. And what the defendant has
by procedural, I don't know whether to call it procedural or substantive. It seems a substantive right to have a district court judge exercise discretion. I don't know whether to label that procedural or substantive.
We would label it procedural, and that the substance is whether he's going to get compassionate release. The procedure is that the district court has to balance the 3550.
But the substance is the outcome. An outcome isn't substantive. This is making the substantive determination of whether he's entitled to compassionate relief. And I don't know, it just strikes me as a little hard to brush off as procedural. If the government went to the district court saying we need a preliminary injunction, here's a showing, and the district court said, I don't think I have any discretion to issue preliminary injunctions, so I'm going to deny it. I think you would quite clearly say that's more than a procedural error.
Right, and I apologize. I'm not a civil lawyer, so I don't know much about procedural and preliminary injunctions. But we may just have to. I may just have to disagree on this and say that from the government's perspective, the substantive outcome.
Well, let me put it in your terms. Let's say the government argues for upward departure in sentencing, and the district court judge says, "I'm sorry. After I've read the latest Supreme Court case, I think I have no discretion to ever do an upward departure." Would that be a procedural error or a substantive error?
I believe that would be a procedural. That would be a procedural error, but in order to show a substantive difference, we'd have to show a reasonable likelihood that we actually would have gotten the upward departure. And that's what we're talking about here, is that David Long hasn't shown a reasonable likelihood he actually wouldn't have gotten compassionately released because this district court believes with good reason he is a danger to the community, could have and would have considered those factors in under the 3553 balancing, actually performed a balancing of sorts. If you look at page 3 of the district court's opinion, the court said, while the court commends Long on these achievements, they do not outweigh the serious criminal conduct for which he was convicted and sentenced. That's basically a balancing of factors just under a different procedural sort of box. And then to top it all off, we have Reginald Douglas's case, where as my opponent has noted, there was a very thorough discussion of the two defendants and an explanation of why there was a different outcome. And there was some analysis of the 3553A factors. So ultimately, the burden to show substantial prejudice to substantial rights is on David Long. And what he has not shown is that given his dangerousness and given that the district court clearly believes he's dangerous, that he would have, there's a reasonable likelihood he would have gained compassionate release if the district court had said, you know what, I'm not bound by the policy statement.
Okay, thank you.
Thank
My
you.
colleagues have any further questions?
So were we to find that this was not invited error? I mean, I hear you relying on Driscoll, but it seems actually quite different from the situation of a jury instruction, because jury instructions have this character of, getting the law correct, but also to some extent actually getting the parties satisfied. And if a party proffers an instruction, for maybe what are partly atmospheric or strategic reasons, and the district court thinks, well, if I were writing it anew, I wouldn't write that, but I'm going to accept that instruction because it's going to obviate a potential, appellate issue. That feels really different from this, which feels to me more like citing a case that's been overruled or citing a wrong case, and where we really, we don't see, like let's say the defendant had cited a case, or a person seeking compassion who cites a case that's been overruled. We wouldn't allow the district court to say, I'm going to rely on that and just stop this person from having an appellate issue, right? It's just legal research, and it's supposed to, everyone's supposed to get it right. And here, nobody, for some understandable reasons, there isn't a guideline that applies. And so it just feels really different. But I'm wondering, really institutionally, from your perspective, as the government, if we were to not find this to be invited error, is that really problematic beyond the circumstances of this case?
No, I don't think it's problematic from beyond the circumstances of this case. I think it's just that if when a party puts a statement of law in the legal standard, that's the law the party wants the court to apply. And if you don't like the law, or you think there's an argument that it doesn't apply, you note that, and that didn't happen here.
Right. And I mean, as I said, I think it's an understandable error for Judge Bates to have made. I think it's an understandable error for counsel for Mr. Long to have made. And now it's very much clearer because the circuits have rallied around and talked about it.
Unless the court has any further questions, we would ask that this court affirm the district court.
Thank you very much, Mr. Habel. Mr. Talai will give you the 2 minutes you requested for rebuttal.
Thank you, Your Honor. I'll just make a few quick points. First, my friend on the other side tried to draw a distinction between Mr. Douglas and Mr. Long by saying that, or suggesting that Mr. Douglas didn't have serious subsequent criminal history, and that's just not true. Soon after the Morrissey murder, he killed another man, and that was the reason that he was sentenced to 25 years to life.
As I read it, the distinction that Judge Bates made was that Mr. Douglas did that at age 20 and Mr. Long did that at age 34.
Yes, Your Honor, I believe it was age 22 as opposed to age 30, around there, 32 to 34. So yes, later into adulthood. But as we've pointed out in our papers, there are cases where district courts have held that, even defendants who committed crimes well into adulthood were entitled to a compassionate release. So I don't think that can be dispositive. The second point I'd just like to make very quickly is that the government has, in my estimation, backed away from the invited error issue and explained for us why it's not problematic here. So I would ask that the court agree.
Mr. Talai, earlier appearance, you pointed out that the relevant standard for dangerousness in 3553 is somewhat different than the one in 1B, whatever it was that the court applied. So as I see it, it is that, and now we're talking about the probability that there would be a different outcome. The 3553A2C allows the court to consider, quote, the need for the sentence imposed to protect the public from further crimes of the defendant. And I think that it blew 20 on your brief. You more or less admitted, I think maybe said say, that's essentially equivalent to the danger to the community consideration that the judge actually applied. And among the things, as I recall, the judge said were that that Long had commissioned killings for revenge and done so when he was wheelchair bound, maybe again, even when he was in jail, I don't recall exactly. And that for those reasons, his release would be a danger to the public, that he was still harbored and showed himself capable of doing these things. If that's true, is there any way that one could overcome that in a 3553 balancing?
Your Honor, I see my time is.
You may answer.
Thank you, Your Honor. Well, I think the point we were making in our brief is not that the two inquiries are the same, just that the court is not prohibited from considering public safety under the 3553A factors. And I think even if you assume that they are similar, there are a wide range of factors that the court would have to consider and balance, and then articulate reasons for why one outweighs another. For example, there is the need to provide just punishment. So, for example, as was the case in the Douglas order, the district court realized that the psychological stress of being incarcerated during the COVID-19 pandemic would heighten the level of punishment beyond what was just. There's also the sentences available. So, for example, a term of supervised release or a term of home confinement. There's also sentence disparities. And these are all, and this is the point of the argument that on the procedural side, which is that, or a substantive, as Judge Millett pointed out, that the inquiry did not occur here. The district court applied the wrong standard altogether because it felt bound by an inapplicable policy statement. And in essence, the court applied the one factor that it couldn't apply as determinative.
You mentioned a limited remand. What were you thinking of? I mean, I understand it's not for resentencing. The sentence has been imposed, so it's only for compassionate release. So is that, when you were talking about limited, were you talking about limited to the compassionate release question or a subset of the issues in compassionate release?
Your Honor, we think the proper course of action here is to vacate and just remand altogether on narrow legal grounds, just as the courts did in Booker, Gunn, McGee, and now Shikambi. But to address the question there was, the hypothetical was assuming that this court would be apprehensive about, the potential for harmless error or prejudice. And I think what I was referring to is that in Molina Martinez, as well in Chavez Mesa, the Supreme Court explained that, when there's some concern about, this harmless error counterfactual inquiry, one option for the court is to, send it back down for the district court to determine in the first instance whether a different sentence would have occurred absent the plain error. And I think that's available to this court.
Colleagues, have any further questions?
Thank you.
All right, thank you. Mr. Talai, you were appointed by this court to represent Mr. Long in this case, and the court is grateful for your excellent assistance in the matter. The case is submitted.
Yes, indeed.
Thank you.
Case number 19-1240, Nuclear Energy Institute petitioner versus U.S. Nuclear Regulatory Commission and United States of America. Mr. Crowley for the petitioner, Mr. Averbach for the respondents.
You may proceed.
Thank you. May it please the court. Stephen Crowley on behalf of the petitioner, the Nuclear Energy Institute. I've asked to reserve 2 minutes of my time. Judge Millett, Judge Pillar, Judge Ginsburg, this is a straightforward case in light of 3 points that I think I can state very briefly. Point 1, the Atomic Energy Act allows the NRC to enter into agreements with states whereby state regulators, instead of the commission, regulate land disposal of very low-level nuclear waste. When the NRC discontinues its regulatory authority in this way, and discontinues is the word the act uses, the state, now called an agreement state, becomes the regulator, and the commission disavows authority over matters within the scope of such an agreement. Point 2, many years ago, NEI's members obtained approval for their disposal of low-level waste from agreement states under the auspices of these agreements entered into between those states and the NRC. Until 2018, these members in places like Texas, Arizona, Washington State had no reason to doubt their state's regulatory authority over their land disposal of low-level waste. And third and finally, in fact, these members had every reason to believe that their approvals from their agreement states governed the disposal of their waste. And here's why. Once the NRC discontinues regulatory authority through an agreement state agreement, it can reclaim or claw back that authority only by a rule, regulation, or order. That language, rule, regulation, or order, also are the words that the Act uses, and those words are echoed in the AEA's implementing regulations as well.
But what about 20.2002, which was on the books the entire time and which clearly seemed to speak to what the NRC is now referring to as a kind of bifurcated responsibility, the responsibility of the generator of the waste to get approval for sending it, and the responsibility of the disposal facility as a disposal facility, which is regulated by, in their view, by the agreement state. And 2002 seems to speak only to the former, and it has been consistently on the books.
So 2002 is not relevant to the regulatory framework that we're discussing, Your Honor. And here's why. 2002 is a sibling regulation, a companion of 10 CFR 150.10. It is that pathway, 10 CFR 150.10, that is the regulatory framework for agreement state agreements. And that's why the government consistently and correctly refers to or agreement state equivalents to 2002. 2002 provides for disposal where disposal is not otherwise provided for in this chapter, but disposal is otherwise provided for in this chapter. That is chapter 1 that governs the AEA through 150.10 and 150.15.
Well, and this is a sort of fundamental difficulty that I have as between your argument and the government's argument, which is that you persistently describe disposal as one thing, and the government is describing two different actions, that the generator has an obligation to, package and transport, and that, there's a getting it to the dump, if you will.
Okay.
And that, as I read their understanding, is that then the dump, and whether the dump is like a safe place, and whether it's supervised, and whether it's leaking, and whether it's, off behind somebody's, country house or whatever.
Sure.
So, and it feels like your ship's passing in the night on that issue.
I don't think so, Judge Miller. It's an important question, so thank you for it. And I want to be clear what our argument is. So our argument is the NRC. We don't have a quarrel with much of the government's position, just the core of its position. Okay, we recognize, we don't argue that the NRC has jurisdiction over the packaging of low-level waste, the handling of it, the storage of it, the transportation of it. What it doesn't have is regulatory jurisdiction over putting the waste in the hole. That they have given up. They have given that up by entering into agreement state agreements. There is and was a robust process for entering into those agreements. They are posted, in the Federal Register. Public comment is invited. State regulators understand that they have authority. So we're not, with respect to, again, packaging, transportation, handling, that is NRC jurisdiction, always has been, always will be. But with respect to disposal at the site, again, turning the shovel over into the hole, that is the domain of state regulation, because so says the AEA and the agreement state agreements the government has entered into.
I just want to clarify, your argument is limited to in-state disposal?
Yes, importantly, it's limited to in-state disposal. Yes, so it's a different ball game if we're talking about interstate disposal, and that gets a little more complicated. And the NRC has provided guidance on various scenarios if I'm taking disposal from one state to another state. We're talking here and as relevant to, again, Arizona and Texas, and of course it was the enforcement action intrastate disposal in Texas that prompted this case.
Except that the documents that are referred to going back to 86, 2012, 2016, 2018, 19, none of those are actually making that distinction, except in specific examples. But in terms of the regime is one that I think from NRC's perspective applies to intra and interstate.
We would respectfully disagree with that, Your Honor. I mean, I'll let the NRC speak for itself, but just to back up a second, we have a framework that says states can approve of land disposal of low-level waste, right? That comes from the face of the act, provided that the state regulators enter into an agreement with the NRC and vice versa. And again, when that happens, there is a robust process to ensure that state regulation is up to stuff. What happened in 2012, as you mentioned this document, is because it was not crystal clear what is required in the multi-state scenarios, the NRC issued what it called a clarification letter, a clarification, not a disavowal of the AEA's framework. It wouldn't have had authority to disavow the AEA's framework, but a clarification letter that spoke to different scenarios. Again, it gets a little complicated on the math, but depending on whether I'm in an agreement state or I'm not, and I'm disposing in an agreement state or not, we have no quarrel with the 2012 document that the court refers to. Likewise, we have no quarrel with the 2016 document that memorializes that clarification. Our beef is with the long-standing authority of states to approve of disposal within their states. And even in 2012, when the NRC renewed Washington State's approval authority, right? It did so recognizing the state's authority in this way. That's at Addendum 9.
You say you have no trouble with the 2016 regulatory issue summary, but had no reason to think that there was a change of position until 2019. But yes, in 2016, the commission clearly said that it was superseding the 1986 information notice. And part of your quibble is that there was no notice and comment rulemaking, but that ship has sailed. So, as you're well aware, one of the questions is the timeliness question of any challenge, given the clarity of the statement. And I understand your position that it was unlawful for various procedural and substantive reasons, yes, but given the clarity of the 2016 statement and, why has that ship not sailed?
Yes, thank you for the question. No, we strongly disagree that this was clear, and I want to say why. It's important here to focus both on the words on the page and the context in which this document was issued. So at JA 16, the regulatory issue summary makes clear that there was an incorrect statement in the 1986 information. And that is a true statement. There was an incorrect statement. What was the incorrect statement? It was a global statement that states always have approval over land disposal of low-level waste. And what this clarification that is referred to in JA 16, also JA 17, is to say that was an oversimplification. The commission is saying we want to correct that oversimplification, that overbroad statement, and we're correcting that by explaining that in a multi-state scenario, again, this is the language that's important at the top of JA 17, matters are different. And we acknowledge that. We had no problem with that. Of course, the same document is very clear-throated that it does not constitute a departure from the regulatory framework. It says that in JA 18. It says there's no notice and comment. We're not doing a backfit. We're not publishing it in the Federal Register. Nothing here to see. I see that my time's about to end.
You may continue.
Right. To put it differently, imagine had we tried to, and we didn't have a beef with it, so we wouldn't have. But imagine, just hypothetically, the NEI, sought to challenge this document. We wouldn't have been able to challenge it. Why? It says it's not. It is simply memorializing the status quo. It is not changing the regulatory status quo. It doesn't require anything of licensees.
Well, you're a better lawyer than that. You don't take that at face value. If an agency says that and it's not the case, you would take it up and say that's not the case.
Well,
they want to say nothing to see here, but that may be part of what you would challenge.
But Your Honor, Your Honor, there's no reason to think this wasn't the case. This on the face of it makes sense with the regime. Again, the NRC knows about these agreements, right? It knows what state regulators are doing. It knows that NEI members are disposing pursuant of state authority. Right. Under the AEA, if it's going to do something dramatically different, it has to say, okay, what should have this document said? It should have said, we are hereby amending 150.10. We are hereby changing the wording of 150.15. We're changing the wording of 2002. But our position is there's a clear way to read this document consistent with those regulations as they are worded then and now.
Well, so what about one way of reading them saying no backfit needed, strictly voluntary, this just ensures compliance with current regulations, and I gather this is the NRC's position, although they can correct me, is that they're saying, 20.2002 requires that even in an agreement state that the generator where it's a nuclear power plant has to get NRC permission to go with an alternative disposal site. And as we explained in the letter in 2012, we went through the 5 different scenarios, and that included NRC regulated generator in agreement state. And even then, the facility, the generator has to get NRC approval. So their view of nothing to see here is not that we're sticking with the 1986 regime. Their view is we're sticking with what we think we explained in 2012 and that we think is codified in and supported by 20.2002.
Well, again, Your Honor, 2002 doesn't say that. It's important to highlight the language here. So 2002 references otherwise authorized in the regulations in this chapter. Okay, so in other words, there is a door in 2002 that recognizes other sources of authorization. And again, that would be
not otherwise authorized in the regulations in chapter 2 dispose of, and it's so again, this is applied to generators, not to the disposal sites. And I'm just, reading the government's brief and trying to get your best answer to it, that their view is that there's nothing else that authorizes a generator to dispose of in an alternative facility. The 150.15 may authorize the site in an agreement state.
It doesn't make that distinction, Your Honor. The regulation says any person. And again, for decades, there in fact have been agreements between states and the NRC allowing for generators to dispose. That is, I don't think the government disputes that. So there is a pathway for generators. There was never any distinction between generators and non-generators. It's any person, nor is there any such distinction made in the act itself, right? The act itself says, look, this is about, state cooperation and enlisting states to do their part and have a say in the disposal of material that is very low risk, as this is. We're saying low level waste. It's a shorthand for very low level waste. So there's no such distinction that has been drawn. And if there were, the NRC could not have entered into those state agreements in the first place. The NRC would not have said in 2012, the same year as this first, clarification letter was issued, by the way, issued only to states, not to the regulated industry, right, would not have acknowledged Washington State's ongoing supervisory authority, regulatory authority over the disposal in that of a generator. It's important. That was in the context of renewing a generator's license. So there was a very clear framework. There was a very clear regulatory before, and now there's a regulatory after, right? And there, if the NRC wants to change its position, that's okay, but it needs to do so pursuant to rule, regulation, or order. So again, so says the Atomic Energy Act, the Commission's own regulations, the APA. This is ultimately about kind of due process, small d.
Mr. Crowley, I have a question. It's not an essay question. It's a multiple choice question.
Okay.
What is it that you filed to review? You petitioned for us to review.
What decision?
Well, what, anything did you ask us to review? You
We
filed a
asked you-
petition to
I
review
see.
something.
I see. We asked you to review the NRC's determination that state approval is no longer sufficient for land
We
disposal.
need an order. What order did you ask us to review?
Well, that determination is
Or action?
embodied.
What action? I shall take it back. What action?
Yes, an action. Yes. Well, it's the action. It's an
What's the date
action.
of the action? Let's start
I'm
there.
sorry. I missed your
What's-
question, Judge.
What is the date of the action? Then I'll know what we're talking about.
The date of the action is September 2019.
Date.
Date, yes.
No, that's a month. What's the date?
Oh, it's the letter from the it's the letter.
From September 16, is that
Yes,
it?
thank you.
That's a letter from the commission responding to
NEI.
your
To the petitioner.
letter, asking them to rescind the RIS, right?
I'm sorry, Your Honor. No, that's the response letter to that letter. That letter was in
Exactly. No,
February.
that's what I meant to say.
Yes, okay, exactly.
There, so you would, the predicate for their sending that letter on September 16 was that you would ask them to rescind the RIS. And the RIS is the 2016 document that Judge Pillard's been talking about.
Not exactly, Your Honor. Not exactly, Your Honor. That letter, the September 16, 2019 letter,
Yeah.
was the culmination of a policy process that the NRC put in motion, prompted by a protest from South Texas, the facility that was cited for it.
Yes, I understand that. Where is I mean, I understand that you're saying the letter is the culmination of a series of actions. But
Yes,
the actions are, if I understand the letter, the actions are to do something based on the 2016 document, the RIS, that you would like them to repudiate.
it's not,
An interpretation that you would like them to repudiate.
yes, that's an important distinction, Your Honor. Thank you. It's the interpretation. It's not the IRS on its face. Again, we had and have no quarrel with the IRS on its face. What
So,
happened? Yes.
Go ahead.
So it's important to draw the distinction between what the RIS says and how it was interpreted beginning in
All right,
August
here,
of
let me-
2018. I'm
And
sorry.
Let me just quote one passage from the RIS of 2016. This RIS, let's see, wait a minute. I got it right here. It's on page JA 17. This RIS makes the clarification that any licensee's request for approval to dispose of licensed material under 20.2002 or the equivalent agreement state regs must be submitted to the regulatory authority that issued the license for use of the radioactive material. It's in the first full paragraph under summary of issue. Second sentence, third sentence. Okay. Now that's what you're complaining about in the policy that you say has been restated or somehow came to fruition only in 2019.
Yes, Your Honor, that's our argument. That cryptic sentence cannot be that cryptic sentence contained in a document that says we are not changing the regulatory framework can't satisfy the APA, the AEA.
Yeah, okay, but as Judge Pillard pointed out, you might well have challenged it if you thought that. Now, there is an enforcement proceeding that's been filed, correct? And I presume all of these arguments will be made there.
It's not so easy as that. It's not so easy as that, Your Honor. And the reason is, in this context, enforcement is a serious business. What's called a minor violation is quickly escalated to a major violation. It's not the industry's practice to say, oh, well, you can enforce against us and we'll see you in court. If the NRC
I understand that that's not preferable, but that's where you are, where one of your members is, I guess.
Well, but Your Honor, it's a circular argument we're responding to that the government's making here, that we're going to take a sentence out of context, out of the larger document it appears, and out of the larger regulatory framework understood by all parties, and say, okay, this sentence means something that it wasn't understood or didn't mean at the time. Why wouldn't the sentence say, we are hereby amending 150.10. We are hereby abandoning the agreement state regime. That's not what the RIS says. What the RIS says is
they should have done that. Maybe they should have had notice and comment rulemaking in 2016. Maybe they should have had a backfit analysis. They didn't do any of those things, and that may have been quite a faulty procedure. but you didn't challenge it.
But
now,
what,
reiterating it, you say, please say it ain't so, take it back. And they say, we're not taking it back. And you now try to say, out of we're not taking it back, we won't rescind it, to use the term you used, to make that into a reviewable event.
I think that we tried to, again, we didn't have a quarrel with this risk when it was written. Our quarrel is how it has been interpreted. And I can only imagine the government's argument if we tried to challenge
Can I
it.
back you up there? You say you didn't have a quarrel with how it was written.
Yes.
Did you consider it ambiguous or confusing?
Yes, we considered it confusing at the time. But
and then did you immediately follow up and say, wait, say the sentence Judge Ginsburg just read, does that mean what we think it means? Or did you just sort of go with the, well, our reading of this is we're going to focus on the language we like and say that this isn't meant to be a change. We're going to understand it this way and hope that works. That's what I'm trying to figure out. It seems like
I hear your question.
Yes, it's at best, right, ambiguous as to what it was doing.
I guess I want to say two things, Judge. First of all, at the most, this cryptic, now very pregnant sentence, right, that is going to be used outside of the broader regulatory framework and this document taken as a whole and taken at face value. At the most, it might be read to say, going forward, indeed, the language is must be submitted on a going forward basis. That if there is a new generator or a new state or a facility that wants to do to seek land disposal on a going forward basis, it would seek that from the NRC. We think that it's unreasonable to say all existing state agreements and the rule that they are moored to and the statute that rule is moored to are hereby wiped away. I mean, that's.
So I'm having trouble with that because I do appreciate that there has not been model clarity and that there's been a little bit of a feeling of a kind of shell game of nothing to see here, nothing to see here, nothing to see here, and voila, at the end of the day, it's a different regime from the one that there was in 86. On the other hand, this at JA 17, where Judge Ginsburg was reading, it follows that sentence for NRC issued licenses, the request should be made in accordance with the provisions that talk about communicating with the commission. For agreement state licensees, the request should be made directly to the agreement state. So it feels, I mean, I may be missing something, but it seems to be saying your hobnobbing with the agreement state is, your approval from the agreement state is not enough.
Maybe on a going forward basis, but how could this document?
Well, Mr. Crowley, I can see how at the time you might read it that way or think of it that way, perhaps reasonably, perhaps not. I just have to be much more familiar with its context. But then the commission said to South Texas in 2018, some point 2018,
yes,
that this is a problem. South Texas, you haven't been complying with this.
Yes.
And then in August of 2018, South Texas asked for clarification, right? The NRC affirmed its position, but declined to enforce. That was October 18. You know this situation now.
Oh, absolutely.
More than a year before there was a document that you sought to characterize as final agency action.
Absolutely, Your Honor. In 2018, to South Texas's surprise, the government relied on this document. Apparently so. I mean, this became clear over time. But there's this back and forth, and South Texas's response is revealing. It said, you can't mean this 2016 risk calls into question our existing longstanding approval from the state of Texas. It was that surprise on the part of
the commission came and said, yes, that's exactly what we mean, but we're not going to enforce.
We would disagree. Not exactly, Your Honor. To its credit, the government said, we'll rethink this. The government, it's important, the government said, you're right, you have raised genuine questions about the clarity of the risk. We are going to hold a public meeting. We are going to take some comment. We are going to,
I don't think that was in the answer to South Texas, was it? That came later, I believe.
No, both, Your Honor. At JA 32, the exact language was the NRC said, we are going to evaluate this issue generically to provide further clarity. So the government is conceding there is not clarity.
Well,
Then-
one could, to be fair, read that as enforcement clarity, that they realize that with a shift and with whatever the practices are, that there's some question about how quickly and in what circumstances people have to come into compliance.
May I respectfully disagree?
For you to point out to an agency, this can happen, I readily imagine with other agencies, say it ain't so, you can't mean it, there's this huge reliance interest. And the agency might say, well, we do mean it. We hadn't thought about the reliance interest. We'll think about that now too.
All of the above. What actually happens? Well, let me make sure I'm responding to both of your questions, which I think is a version of the same question, but you'll correct me if I'm wrong. South Texas protested. The agency said, you're right, we will provide further clarity. You have raised legitimate issues. You have caused us to evaluate the risk. That's what they said, to evaluate the risk. At JA 48, there's a meeting notice. What does it say? I'm quoting, discuss a path forward to address concerns with the risks. And lastly, importantly, JA 54, 55, 56, summaries of those meetings. And the language makes clear the agency, look, even if you think, which we strongly disagree with, that we could have, sued on the basis of the 26th, but even if the court were to conclude that, the agency reopened a policy process, ran a policy process to consider revisiting the risk. And then—
you know that that's not how they characterize it. They characterize it as information sessions and trying to be transparent and respond to the outcry, but not reopening a policy process.
Well, I don't want to quibble over words, Judge Pillard, but what they said is we're going to evaluate the issue generically and discuss a path forward to address concerns with the risks. Any reasonable, let me just back up. Any reasonable—
Yes, I'm sorry, I have to say, I'm sorry. I don't see them saying, first you said that they're going to reevaluate the risks, and I don't see that in their letter. And then now you just said what they said. They evaluate the issue generically to provide further clarity.
Mm-hmm.
I don't see them saying anywhere that we're reevaluating the risk itself.
So I'm looking at JA 32, the only full paragraph at JA 32,
Yep. Mm-hmm.
Yeah.
the second sentence. The NRC is evaluating the issue generically to provide further clarity.
Right.
And
Right.
then-
Yes, but in the previous
Further-
page, they had
Further
said,
up in that, yeah, go ahead, Doug.
I'm sorry, they had said at the bottom of the penultimate paragraph, and however, NRC authorization for South Texas to use these sites of this material is also required. Okay, so they're adhering to their position
Yes.
in regard to this particular enforcement action.
Yes,
And
we
then
agree.
saying, we've raised some issues and we will think about those, but they're not in this case.
Well, they're sticking to their position. We agree, but they're also. This is to the government's credit. They're also saying to its credit, like you've raised some issues, we will work through them. The alternative is, okay, the whole industry is asleep at the switch. Every generator in an agreement state is asleep at the switch. Every state regulator is asleep at the switch. Again, this is regulation by gotcha. That's not what the AEA prescribes. The AE prescribes, the APA requires some process, some transparency, some notice. Give the industry a chance to weigh in. You can't put one sentence in a document that says this does not disturb the regulation.
That sounds like a great challenge on the merits to the agency's decision. And what we have to decide first and foremost, though, is when was that decision made?
It was made sometime between August 2018 and
I think under the Hobbs Act, you got to have an action that you're challenging, and as Judge Ginsburg started, you have to have a date.
yes.
And so sometime between 2016, then you probably should have started in 2016 with a challenge, and then everything could have gotten cleared up quickly.
But you said between 2018.
Yes.
2018.
With the citation, the commencement of the enforcement when the commission signaled, okay, maybe we got ahead of our skis. And yeah, the decision, the embodiment of the determination, the order for the Hobbs Act purposes is the letter response to the industry, right? That letter, by the way, was foreshadowed in the public meeting. They said, okay, we hear you. We will get back to you. I'm paraphrasing, but not loosely. We expect by the end of September to respond to industry's concerns. So naturally, the NRC sends an authoritative letter to the industry's group, my client, the petitioner, and says, here's our answer. So that easily satisfies Hobbs Act. There's lots of circuit law on a letter from an authoritative agency official that constitutes the culmination of an agency process is a Hobbs Act order.
Actually, the principal case you cited for that also had an enforcement letter in it. I think it was Barrick.
Barrick, yes. Appalachian Power,
Yeah.
Valero.
I wondered about why, Mr. Coley, the Institute didn't just seek a rulemaking, just petition for rulemaking, because wouldn't you have clear, I mean, couldn't you still do that? You have clear avenue for review from a denial of a petition to make the rule that you think you thought was in place. The agency denies that, and then off you go to court.
It sounds simple, Judge Billard, but in the meantime, there are enforcement risks. They are expensive. They raise reporting requirements. They implicate insurance arrangements, right? So the rulemaking process, even a pretty quick one, as the court's well aware, that is not an appealing avenue. I think you're right. As a formal technical matter, that has not been precluded. But the fact remains, we have a decision, an order, a decision, and the agency has articulated a viewpoint that's inconsistent with the procedural requirements of the Atomic Energy Act. Run a process, give us a say, do something transparent, not this regulatory gotcha.
Colleagues have any further questions?
Not now.
We'll give you some time on rebuttal, Mr.
Thank you.
Mr. Averback.
Good morning, Your Honors. May it please the court, Andrew Averback from the U.S. Nuclear Regulatory Commission on behalf of the United States and the NRC. This petition for review challenges the NRC's determination in 2019 not to rescind at NEI's request an interpretation of its regulatory authority that the agency staff formally announced in 2016 and had in fact been articulated as far back as 2012. I have to confess that I was somewhat surprised to hear from NEI's counsel that they actually have no quarrel with either the 2016 or the 2012 or the 2016 guidance. The fact of the matter is that those are mere interpretive rules that the staff.
Can I back you up? Is the decision not to rescind your position a final agency action? You just said they asked you to rescind it, and you said no.
Well, that's what they've identified in their petition for
I'm asking you, as a decision not to rescind a reviewable action under the Hobbs Act?
If it had appreciable legal consequences, it could constitute final agency action that's reviewable. But
it certainly does have appreciable legal consequences. That means they're clear, and they have to go for the industry-wide has to go forward now and change their application processes for waste disposal in a dramatic way that they hadn't before.
Well, that's what they say now, and they somehow suggested that they were somehow illuminated in that regard by virtue of the 2019 letter. But I point the court
the 2019 decision not to rescind. The
The
agency decision not to rescind. Yes. Wait.
Sure.
Yes. So they've
but-
identified harms and appreciable legal consequences. I didn't hear you in your brief saying those are not appreciable legal consequences.
Well, I want to make clear that as an initial matter, any appreciable legal consequences that may result from the agency's interpretation don't come from the 2019 letter. And in fact, I would draw the court's attention to JA 42, which was the letter that NEI wrote to the NRC after this sequence of events that Mr. Crowley described. And the position that NEI is adopting here, this sudden illumination that, oh my gosh, now licensees who had previously existing arrangements are now going to have to comply with NRC requirements. NEI acknowledged that very circumstance back in February 28th, 2019. And this is on the bottom of page JA 42. And it wrote, quote, the interpretation provided in the RIS, Regulatory Information Summary, requires, they actually emphasize the word requires, licensees that have obtained approval from an agreement state for alternate disposal of LLW to obtain approval from the NRC prior to continuing such disposals or risk enforcement.
I understand that. That was based not on the risk itself, but on the subsequent enforcement action against South Texas. So,
well, I mean, the statement says the change, I'm sorry, respectfully, it says the changed interpretation provided in the risk.
Mhm.
So they fully understood the consequence of the risk.
No, I don't. I think we just need to stop and be fair here. Okay, let's just be fair all around. I understand your arguments about the risk. Do you dispute that prior to 2016, the long-standing established practice was that the agreement state provided the approval, assuming it's in the same state? That's all I'm talking about. The agreement state provided the approval for disposal of low-level waste. Do you dispute that?
I dispute that in as much as it suggests that it was prior to 2016. In 2012, the agency.
No, that was about interstate quite clearly. Well, you guys issued guidance in 2009 on low-level waste disposal processes. And that guidance said, for reactor licensees submitting 20.202 requests, if both the reactor and the proposed disposal facility are located in the same agreement state, typically the state regulator will perform the review of the request, not NRC staff. That's your 2009 guidance. So let's start with that question. As of 2009, was the practice that the agreement state provided the approval and not the NRC?
I would say that in some circumstances that was the case.
No, what circumstance? Tell me what language in this your guidance from 2009.
Well, what I'm trying to suggest is that candidly there was a bit of a mess, and I don't deny that. But we've cited to two different Federal Register notices reflecting licensees in agreement states seeking NRC approval prior to 2012. I don't recall the exact dates of it. I believe one of them was 2010, one was 2005. And going to the NRC.
How many?
I'm sorry?
Two out of how many?
I don't know the denominator in that.
I'm right. More than two.
It was more than two. We pointed to those two because they were published and the court could take judicial notice.
So, all right, and you just said at best you had a mess, but you had a 1986. I forget all these different names you have for these things, but a 1986 notice.
Right.
And then you had in the late 1980s a proposed regulatory amendment that would do exactly what you now say the risk did and was withdrawn. But an acknowledgement that you had to make any change to the 1986, that practice memorialized in 1986 through a regulatory process. And then you have this 2012 letter that comes along. Well, you got this 2009 guidance, which I don't think has been replaced until your 2020 guidance. Unless you can tell me you've had intervening guidance that changed that language that says the states are going to do it generally.
No, Your Honor, we embarked upon.
That was the guidance that they had. States are going to do it. So you had conflicting stuff all over the place. You had tried a regulation and then withdrawn it to make this very change. And then you have a 2012 letter that's talking really, at least as I read it, most fairly about interstate, which is why I limited my question to in-state. And then you've got this risk, which has language that's been quoted that seems to say we're changing our position, but for an agency that had said we're going to try to do it through a regulation and we're withdrawing that and we need to do a regulation, and now to have this in the risk, industry is confused. You might be right, you might be wrong. That's a merits issue whether the 2016 risks lawfully accomplished that change. And you've got language in there that seems to announce the change. But this seems rather, it seems rather odd to me that on issues of this importance, the NRC buries such a massive change in a sentence in an issue statement rather than a regulation, and then adds to that very issue statement, compliance with current regulations is strictly voluntary. The compliance with the risks ensure it'll be strictly voluntary on page JA 18. I can't blame them for being entirely confused. I mean, does the NRC at least acknowledge this is not good government, how this has been done?
Your Honor, there are a number of things.
Strictly voluntary.
What we meant by
strictly voluntary.
I'll start with that. When the agency said it was strictly voluntarily, what it was referring to was the fact that 22,001 sets forth a series of different ways in which a NRC licensee can dispose of low-level waste, one of which is to deliver it to an authorized recipient under 22,001A1. Then there's a list, and there are several enumerated methods that have been approved through notice and comment rulemaking. The sort of safety valve, if you will,
that's not what the sentence says.
Well, if I,
2018, and any action that licensees take to implement changes or procedures in accordance with the information contained in this RIS ensures compliance with current regulations is strictly voluntary.
if I may finish, Your Honor, when it says it's strictly voluntary, what it's saying is you don't have to capitalize on the 22,002 safety valve. You can use any of the things that the agency has previously evaluated through a notice and comment.
Not what it says. That's not what it says. That's just not what it says at all.
But the point that no license
get out of the backfitting. This is all to get out of backfitting. That's it's not. You wouldn't have backfitting if we wouldn't have any backfitting obligation if they were just going to use already approved forms of disposal. The only reason you're talking about backfitting is something must have changed, or someone might think something changed.
Well, right, and that's why at the beginning of that document of the regulatory information summary, the agency made clear that it was rescinding the prior guidance, that it was incorrect, and it was superseding the entirety of that document. And this attempt to sort of refashion it as only partial repeat, a partial superseding or partial repeal of the prior guidance, I think it isn't a fair characterization of what happened. The agency recognized that it had provided inaccurate guidance and confusing guidance in the past. It endeavored in 2012 and then in 2016 to replace that guidance with something that was truer.
I don't think there's any way to say that you endeavored to be open, clear, and transparent in 2016, because you were, coming and going in the same document.
I respectfully disagree with that, Your Honor, but I certainly, I think that, as I made clear when I cited to page JA42, NEI understood the consequences of what had been done in 2016 when it said this new regulatory information summary requires its language us or our licensees who have these pre-existing arrangements.
It also says it's informational and pertains to a staff position that does not represent a departure from current regulatory requirements and practice.
It says that, Your Honor, and 2 points about that. Number one, the current regulatory practice was based on the 2012
letter about interstate. As to in-state.
Well, if I may, Your Honor, some of the, I believe the first scenario in the 2012 letter actually referenced an interstate situation. So while that was what was being discussed, and I think this is an important point here, we're not focused, the regulation and the statute, the regulatory basis for the agency's position doesn't depend on whether or not we're in an interstate or in an intrastate situation.
They were supposed to discern this from a letter that wasn't the regulated parties here. We're supposed to discern from a scenario in a letter to states, not to them, that was never published.
Well, Your Honor, that's why.
That's when you're saying the change happened in scenario 4? That's how you openly and clearly and transparently change?
Well, Your Honor, I
practice without bothering to change your guidance to industry?
If I may, Your Honor, there was continuing ambiguity post 2012, which is why the agency further attempted to clarify the record in 2016.
Okay, but then so if there was continuing ambiguity between 2012 and 2016, then the current state would have been ambiguity and would have included, I think, countless, maybe not all, maybe there were 2 exceptions, but there would have been countless plants that were relying on their agreement states to approve low-level waste. Would you agree with me that that was the state of practice up to 2016, that was going on?
I certainly, the 3 licensees that NEI has provided affidavits from were subject to that. I'm not aware of there being any
really
more.
NRC, how many applications did NRC get between 2012 and 2016 to approve low-level waste in an agreement state?
Your Honor, candidly, I don't know the answer to that. But what I do know,
if you were getting flooded with them, you would have known that.
Well, I can't suggest to you that we were getting flooded with them.
And your guidance at the time told them, don't bother coming to us. It's not for NRC staff to approve.
Right, which is why we endeavored to provide further guidance in 2016 and to remove any existing confusion that may have continued to exist. I wanted to make the fundamental
You really
point.
think this was the clearest you could have said it?
I
We're
suppose
not departing from
Well,
current regulatory practice. We're not departing from current practice.
if I were to go back 5 years in time, perhaps I would have written it differently. But what we're talking about here is a position that NEI understood, that NEI understood the consequences of, and that fundamentally stems.
Let's not put words in your friend's mouth there. It didn't understand the consequences, at least before the 2018 enforcement action.
Well, okay, I don't
And the
necessarily agree with
company
that.
there, South Texas, was surprised.
It may well have been. I don't
Yes.
know.
So much for your clarity.
Can I ask a slightly different question? Which is, I think in your brief at an abstract level, you do a helpful job of distinguishing between what's involved in regulatory approval on sending generator side and the regulatory approval of the receiving disposal facility side. I mean, it seems to me that that's fundamental to your position, that these are two separate functions, or at least can be. And in the view of the commission, it's important to, when NRC licensed generators are involved, it's important to keep them separate, and that the sending side, just for shorthand, is not delegated to agreement states. So I understand that in a sort of abstract sense, and for its part, the Institute refers to the Commission's new interpretation requiring duplicative NRC approval. And then I thought it was very helpful. Mr. Crowley today said all he's concerned about is what I refer to for shorthand as the dump, putting the stuff in the ground. Can you just in somewhat more concrete terms explain what the distinct inquiries are? Where under the 2016 regime, where the NRC is looking at the generator's permission to use an alternate site, and the agreement state is looking at the alternate site's eligibility. What's going on? What are they regulating? What are they looking at? How do they differ? In a really functional, practical sense.
Okay, I'll start with the proposition that the NRC is not regulating what Your Honor refers to as the dump. That is not an NRC licensee, at least in agreement states. And so the NRC isn't somehow taking away jurisdiction from agreement states to regulate the place of the dump, the actual depositing of the material into the ground. Those are all decisions that the states remain free to make, consistent with
not the putting it in, not the lining, not the supervision of it, not the freedom or not from water. So
those continue to be within the state jurisdiction.
Right,
but what the NRC, I'm sorry to interrupt you, Your Honor.
No, I interrupted you.
What I'm trying to get at is this idea that under 10 CFR Part 20, which is applicable to all NRC licensees, including those who are licensed under Part 50, Part 50 being the one where all the nuclear power plants have received licenses from the NRC. Part 20 requires NRC licensees, including nuclear power plants, to submit a plan for procedures to be employed for the sort of post-handoff disposal of low-level waste. And the reason for that is that the NRC doesn't want material transported off-site without understanding that there is a plan that has been previously evaluated and approved by the NRC, either through notice and comment rulemaking or through at least understanding what the plan is. The NRC wants to make sure that
you refer to procedures, you refer to packaging and transportation, You refer to the method by which they seek to dispose. You refer to the handling of waste before it becomes subject to agreement state authority. And you distinguish between the disposal method and the disposal itself. So what is in the former category in all of those dyads? What is the procedures that the NRC needs to supervise before the low-level radioactive waste is at the dump?
Well, the NRC has to understand what the radioactive dose of the underlying material is. It has to understand the time it's going to take for this material to actually be disposed of as a function, which will dictate in turn how much exposure employees or the public may have to this waste. It needs to understand.
Can I just clarify?
You mean in transit?
Are you talking? Yeah, are you talking about in transit or at the dump itself?
In transit and up to the point where it is accepted for disposal
Well,
by
that's transit. Right.
Okay.
Yeah, it's transit, but keep in mind that we're going back.
Isn't transit already regulated?
It is.
And isn't packaging already regulated?
Sure, but this is part of the NRC's, what it refers to as its defense in depth approach to making sure that all the I's are dotted and T's are crossed.
So what the point is, all right, so I'm very simple on this. So I've got a barrel of this very low level waste sitting on my nuclear plant site, and I've done everything lawfully in packaging it up consistent with regulations, and it qualifies as low level waste. There's no dispute about that. So the packaging, the definition of low level waste is already addressed and been resolved. The packaging is compliant with existing regulations. I'm using an approved transportation system to the dump. So tell me exactly what again it is that you're regulating under. Are you asking them to? I'm really confused. Are you asking them to document that it's low level waste, to document that they're using the right container, to document that they're doing the right transportation? It's just documenting the regulations you already imposed, or is there something else when it goes on the NRC approved truck and drives in the NRC approved way to this agreement state approved dump?
Well, we want to understand what they're going to do with it once it gets to the dump. For example, are they going to open?
Right, so this is where I'm very confused. So I thought you said once it gets to the dump, the state takes it. I'm sorry, Judge Millett, I don't mean to jump into your question. I'm just very confused. What do you mean when it gets to the dump? I thought you said the state took care of that.
The state regulates that. Certainly the NRC has a role to understand what exactly is going to happen, and it's within its
at the dump.
Yes, and again, it's not.
I thought you already cleared all that when you license someone to be an agreement state. Don't you go through all that already?
When we license someone to be an agreement, for lack of putting aside the nomenclature, essentially yes, but we as Part 20 licensees, and this is part of the legislative rules that are in place that all NRC licensees must comply with. They still need to comply with 22,002 so that the NRC, before it just simply authorizes waste to be driven off to some out of state.
Your language keeps changing. I don't want to talk about out of state. I only want to talk about in state. Don't give me out. Okay, I don't want to.
All right, I didn't mean to qualify. Okay. Our position applies in state and out of
right,
state.
So on in state, I don't know what procedures you're regulating because you said it's not at the dump. It's the plant's procedures and getting the stuff to the dump, but then your answers have been all about, well, what's the dump going to do with it? But that's what you said the state's regulating, and you are not policing. So you can understand why industry is profoundly confused here.
I can understand their reluctance to be subject to dual regulation, but respectfully, I don't think that that's what's going on here. The agency is simply saying, look, before we can authorize anything to leave a site, and whether it goes in state or out of state, we want to understand what you plan to do with it. And we want to understand either
dispose of it at an agreement state approved. I mean, has there been a problem that they haven't been taking it to agreement state approved locations?
No, but
the agreement states haven't been doing what they said they would do at their disposal sites?
Well, we have, I can't speak as to whether or not there's been an individual problem or not, but I'd like to attribute the lack of problems to the fact that we have regulatory requirements in place saying, hey, look,
But
before
you
this goes
didn't,
down,
your compliance manual didn't require any of this. So it hadn't been done before, maybe 2018,
well,
2016. So, but I
we are
still
forever
understand-
trying to improve our processes. I don't think that that's a bad thing.
change your processes.
Um,
But I'm sorry, I don't mean to interrupt Judge Pillar's question, but I don't understand with my barrel what it is that you're approving under 2002. What is it that that you are approving that you haven't already approved by authorizing the agreement state to handle the disposal stage?
Well, the point is that all of the other methods in 2001 have been approved by the agency through notice and comment and rulemaking. When a licensee tries to use the safety valve of 2002, this is something that the NRC won't have previously considered. And the agency is simply saying, just like all the other provisions.
Didn't you consider it when you agreed with an agreement state that they're in charge of disposal? I guess I thought you told Judge Pillar that you were not regulating the disposal site, that was for the state.
We are not, but we want to understand what is going to be done, what is proposed to be done.
By whom?
By the licensee.
By the licensee at the disposal site?
Yes.
What do they do?
It's information as opposed to regulation. It's saying before we sign off on the facilities in our primary regulatory ambit, before we sign off on them passing this off to a state supervised dump, we want some communication about why the state is satisfied that this is going to be secure. And
I think that's
some of the information that they're in charge of, but we just want that information. And also, but that's not the only thing. There's also, as you say, questions about packaging, transport, timing, and the like of the low-level nuclear waste. So there's
I think that's a fair characterization.
I mean, by whom?
By the generator, as I understand it. Can I ask you on the
wait, I'm sorry, is it timing by, are you talking about timing, how long it takes to
but when it's going to happen, how long it's going to take.
What's the it? I'm sorry, I'm getting confused.
The transportation, the amount of time to which the amount of time that the material might be exposed to the air, things like that.
That's okay. So the amount of time exposed to the air, you mean in the transportation process, or do you mean in the dump?
I mean in the dump, but I also mean how long it's going to take to transport it from point A to point B, things like that, which have to be worked
So you are
out.
regulating the dumps now too.
I wouldn't suggest that, Your Honor. We want to understand what's happening before we authorize shipment off-site, and frankly, to, if necessary, communicate with the state authorities to make sure that we're all on the same page.
Will the plant know how long the people operating the disposal site take to dispose of it once
The procedures would
Who would have
contemplate
that information?
or when something's going to happen, for sure.
Wouldn't the state have that information? They're the one that licensed the disposal site.
There have to be procedures, and to be clear, Your Honor, there are the facility, the disposal facility is licensed by the state, but they don't necessarily know what their customers, for lack of a better word, how they necessarily intend to operate. And there's each
problem in the state. Okay, so what you're addressing here is a problem that states are not policing their disposal sites well enough, and so you want information from the plants about how the disposal site that's been licensed by the state in an agreement state is actually doing it?
Well, I wouldn't characterize it as the agency addressing a problem. I think it's preventing a problem so that it understands what is going to happen to this waste.
At the disposal site?
Yes, at the disposal site.
Okay. Sorry, Judge Pillard, I interrupted you. I apologize.
So what's your response to Mr. Crowley's point? I had taken you to be relying really quite significantly on 20.2002. And Mr. Crowley says, well, but that's only half the story. That really doesn't apply here at all. What we're really, I think if I'm remembering correctly, he said, what we're really looking at here is 150.15. And I had read that as actually not exempting this activity, but I'm a bit of a novice in this area. So can you explain why you think that his answer is not problematic from your perspective?
Yes, and I'm glad the court raised that, because that's an issue I would like to address. I don't think it's correct to say that NRC licensees are exempt pursuant to let me begin that sentence again. I don't think it's correct to say that any NRC licensee is exempt from NRC regulations merely because they happen to be in agreement states. And that's effectively the import of Mr. Crowley's argument about 150.10. And in particular, nuclear power plant licensees, which is what we're talking about here, actually don't fall within the scope of the 150.10 exemption, because they will necessarily, and I'm quoting here from 150.10, they will possess special nuclear material in quantities, it says here, not sufficient. The people who get exemption are not sufficient, the ones who have it not sufficient to form a critical mass. Nuclear power plants have special nuclear material in quantities sufficient to form a critical mass. And what that means is that they're not somehow exempt from NRC requirements. And what that further means is that they are therefore subject to all of the requirements set forth in 10 CFR Part 20, including the need to comply should they choose voluntarily to pursue an alternate means of disposal, the requirements of 20.2002. And so there's no need for the agency to somehow claw back jurisdiction over nuclear power plants. Nuclear power plants are subject to NRC regulation.
I'm sorry. Yeah.
No, sorry.
I was just going to say, I gather incorrectly referred to one. I think Mr. Crowley mentioned both 150.10 and 150.15. And is the waste we're talking about here covered in 150.15? Non-exempt specifically, I mean, A4 or?
We're not invoking the clawback provisions of the 150A4. But to be perfectly clear here, we don't feel the need to somehow suggest that that the disposal of waste is part and parcel of plant operations. It's the need to comply with Part 20 exists irrespective of someone is or is not is or is not a power plant. The need to comply with Part 20 stems from the fact that you, as an NRC licensee and someone who is not exempt under 150.10, need to comply with all applicable provisions of 10 CFR, including 10 CFR Part 2001 and 2002. And to really drive it home, 10 CFR 2001 says a licensee, meaning any kind of NRC licensee, including a nuclear power plant licensee, shall dispose of waste only, it says, in accordance with any of the enumerated methods, one of which happens to be 2002. But an NRC licensee is bound by that provision, and that provision
is one of those approved methods operating within an agreement state.
Is an approved method of disposal.
All the things that they can do. Yes, for only because the agreement state provision statutorily only applies to very low level, low risk aspects of nuclear material. No one's suggesting anything that's remotely risky goes out of your hand.
Well, I don't think that's the point of your question, but I'm not sure that that's a fair characterization. So,
what's not a fair characterization? No, please educate.
I don't think it's fair to say that the mere fact that it's a low level waste doesn't mean that there are not hazards associated with it.
I didn't say that at all. I just said that the agreement state program, as I understand it, is the only thing as to which the NRC will, in the NRC's word, discontinue its regulatory authority is specified low level risk aspects of nuclear power production, right?
Okay.
And discontinue is the NRC's word, correct? Discontinue regulatory authority as just to those aspects. Is that correct?
That is correct. And that's
Did that
why
include disposal, allowing agreement states consistent with your 2009 guidance, which has been in existence at least till 2020, allowing the agreement states to approve the disposal of inland low-level radioactive waste in state. Was that?
yes, Your Honor, and that's I don't think I'm disagreeing with you when I say that the agency has not undermined or prevented states from maintaining full authority.
No, I was
pursuant
responding to your argument that you hadn't given up any regulatory authority and you weren't clawing anything back, but then your own verb is discontinue regulatory authority. Obviously, very cabinet, very narrow, but discontinue sounded to me like you were take over that
the sense in which the sense in which the NRC's authority is discontinued means that it does not regulate the recipients of nuclear waste, the facilities at which
that's not what your
waste may be
2009
disposed
guidance
of.
but that's not what your 2009 guidance said.
Well,
Approval of, for purposes of 2002 request, the state regulator will perform the review of the request and not NRC staff for reactor licensees.
well,
Not
again,
for the disposal places. It says for reactor licensees submitting 20.2002 request. The reactor and proposed facility are in the same state and the same agreement state. The state regulator will perform the review.
well, that's why the agency endeavored to correct that guidance, Your Honor, which is
Didn't do
because
that till 2000, till last year.
well, right, and that's why, in fact, the agency responded to both NEI and to South Texas and said, we are endeavoring to provide additional guidance as to what to do, having recognized that the prior guidance had not necessarily provided all the accurate information. Now, that's not what's at issue anymore, though. What's at issue and right now is whether or not in 2019, when it said, no, our interpretation of our own legislative rule is correct, whether or not that constitutes final agency action.
Right.
But
Can I say one other thing too? When I know with Texas, and there was a statement there that you would, because of all the confusion, would exercise enforcement discretion. And so does that mean when you exercise enforcement discretion, I assume that means there's not going to be any kind of penalty or write-up, but does that, I assume they still are expected to come into compliance going forward?
well, what the letter to South Texas said was, we won't seek any kind of enforcement for past conduct. And until we put forward this guidance, we won't likewise, we'll allow you to permit to continue to dispose of waste in accordance with the existing arrangement with the state of Texas. The implication, I think, from that letter is after the issuance of guidance, now you've got to comply.
Oh, okay. So then there wasn't actually a regime requiring them to change their behavior until the guidance issued. So in 2018, they still didn't even have to change. Was it just South Texas or all of industry wasn't expected for in-state disposal, wasn't expected to change until you had the new guidance after your meeting and everything?
We expected the licensees to comply, and really the guidance and the specific thing that we wanted.
Texas.
Well, one of the specific things we wanted to address with respect to licensees like South Texas was what to do with licensees like South Texas that had, in fact, previously obtained an authorization from the state. We've been notified about 3, and I have to confess, one of them we only learned about through this litigation, meaning Arizona. But the remaining licensees who have been aware of this obligation since 2016, at least, I think, as was pointed out before, they didn't sue. And in fact, what I've heard is that they actually don't disagree with the underlying logic of the agency's position. And I think it is correct to say that had they disagreed with it, we probably would have been in court. It's strange to me that here we are 3 years after the issuance of the 2016 Regulatory Information Summary, that NEI is advancing the interests of 3 of its members when it actually
any enforcement actions against anybody?
And a violation was, the existence of a violation was communicated to Energy Northwest in, I think it was 2019. And that's referenced in the briefs. To my knowledge, that's the only one.
So, Mr. Averbach, just zooming back and looking at this at a much more simple level, the commission has acknowledged that its interpretation of 20.2002 has shifted, at least from the interpretation announced in the 1986 information notice, which it refers to in a 2016 regulatory issue summary as incorrect. But at the same time, the commission has said that none of the particular communications has created any new legal obligations for NRC licensees. And is that because no enforcement action has yet been taken, or what? I mean, it seems like if the interpretation has shifted, there is a new legal obligation. And when and how did that crystallize?
I think the clearest answer I can pose to that, or put to that question, is that the obligation itself doesn't stem from the NRC's staff's interpretation of the regulation. It certainly, if licensees voluntarily choose to comply, that's their own decision.
The obligation stems from the regulation, but the agency had an authoritative interpretation of the regulation in '86 that it didn't apply to in the way that you've now said it does.
Now meaning sometime between 2012 and now. Yes, I agree with that.
And so the question is, given that, I mean, maybe the position is, well, I gather the position is that the 1986 interpretation was wrong and invalid, but nonetheless, it was something that had some operative force. And so if there's a change, what's really confounding is that the agency has both said, yes, we've changed our interpretation, but at the same time, it said nothing to see here in 12, in 16, in 18, in 19. And the nature of the nothing to see here has shifted, but it's sort of like, when did the agency say, okay, rubber's hit the road here, folks, you know, let's bracket the enforcement issue, but you've got to do this. Like, has that yet been done?
Well, I think the 2016 information summary accomplishes that task when it says that NRC licensees, as distinct from agreement state licensees, have to go to the NRC in accordance with 2001 and 2002 in order to get approval for alternate disposal methods. I understand that we communicated, the NRC, I think, had a sense that this was public knowledge in 2012. I understand Judge Millett's concern that perhaps it could have been stated more clearly and more expansively to both intrastate and interstate situations. But
Mr. Crowley's client might have had an opportunity to say, okay, you should have done a backfit, or you should have done notice and comment, or whatever, but that's time barred in your view.
Yes, I would agree with that. Now, there's certainly other opportunities for those particular clients to contest the agency's interpretation or to seek judicial review, but it's odd here to write a letter to the NRC in 2019 and have us simply say, no, we meant what we said in 2016, and to have that suddenly be the impetus for judicial review under the Hobbs Act. And I want to emphasize this too, because the Hobbs Act has specific qualifications on what this court is empowered to hear that tie back to Section 189A of the Atomic Energy Act. And in particular, the only avenue that NEI could get this court's jurisdiction right now is if what it's reviewing is a final order in a rulemaking proceeding. And I understand that the court has said that, okay, when the NRC issues a legislative rule that those legislative rules fall within the meaning of a final order in a Section 189 proceeding. But all the agency has done here is adhere to a previously existing interpretive rule. And
So under that theory, would a challenge to the 2016 RIS have qualified for Hobbs Act review? Because you said that was just adhering to 2012. 2012. So would a challenge to 2016 RIS have?
Your Honor, the agency's position and the government's position is that an interpretive rule is not cognizable in a Hobbs Act proceeding. I want to make clear.
Wait, I just want a yes or no answer. Would a challenge to the 2016 RIS have qualified for Hobbs Act review?
I don't think it would, but I want to.
RIS doesn't qualify under the Hobbs Act under your view.
In my view, yes. I do want to just make this qualification, though, that there is a case from 1982 entitled New England Power Company versus NRC, which purported to challenge what it called an interpretive rule. Didn't really assess jurisdiction, but when one does a search of previous cases, it is, in fact, analyzing an interpretive rule. I don't think that's proper under the Hobbs Act, and the Third Circuit has held otherwise in the case of New Jersey versus NRC. But I think that
just to be clear, that the agency's position is that the only way to challenge this change, I think, would be through an actual enforcement proceeding. Is that right?
An enforcement proceeding, the court referenced the petition for rulemaking, which is an avenue too.
That's a pretty hard avenue. Okay.
I don't disagree that the standard of review was favorable.
Right. I just want to be clear that your position, because I had misunderstood from your brief. I had thought you said they should have challenged the 2016 RIS, but now I understand. You've clarified for me. Thank you. That you don't think that could have been challenged either under the Hobbs Act.
Fair enough.
Thanks. Sorry.
Let me make sure I've caught up with this then. So, Mr. Averbeck, so you're saying the only things that are challengeable are the product of a notice and comment rulemaking or the final order in an enforcement proceeding?
In this particular context, yes, certainly an adjudicatory decision that the agency makes, which we see all the time in licensing proceedings, are subject to Hobbs Act review as well. But the judicial review provisions under Section 189B of the Hobbs Act are tied back to that which is set forth in Section 189A. And Section 189A is limited to proceedings of 3 or 4 different types, one of which is a final order in a proceeding issuing or modifying a rule or regulation, and the language that the Act uses is dealing with the activities of licensees. So a final order in a rulemaking proceeding, and which I think is appropriately read to include legislative rules like 22,001 or 22,002, but not interpretive rules, would be reviewable, as would be a denial of a petition for rulemaking.
Right.
I have just
and
one
anything
question.
coming out of an adjudication.
Yes.
Why does everything take so long?
Can the court be more specific?
Well, there's a reference in each of the communications to the regulated community and to the states. The agency sort of hopefully says, "Oh, but we're going to issue something. We're going to clear this up." You know, forthcoming is more guidance, and then years go by. For example, at JA 14. In order to inform licensees and interested stakeholders, this is the 2012, specific guidance is under development. This will be shared once it's been finalized. And 4 years go by. And then there's the 2016. And then 2016 talks about, I think similarly, further clarification. Anyway, you get the picture, and then and then there's a meeting, and they just sort of keep saying, like, we're going to think about this, and it just years and years go by, and so I just thought there was something about the industry or about what's happening in the interim that isn't apparent from the paper.
I can't necessarily give a comprehensive answer as to why things take the length of time they do. One thing I can point to, though, is that the NRC has actually endeavored here to be to improve its processes, to listen to interested parties. And one of the things we point out in our brief is that when NEI wrote this letter, the agency said, "Hey, you know what? We'd like to get the views of interested parties." And yes, I think that's a desirable means of governing. But the flip side of it is that it can take time to arrange this, to hear what licensees have to say, and not just licensees, but other stakeholders might have to say. And regrettably, the process may take months, years, and we find ourselves in a situation where we're in. But I do think that the agency has endeavored to fix a problem. It began that in 2012 when it realized that there was a mismatch between what licensees were doing under 2002 and what some of its original legal analysis had suggested. And since 2012, it has been endeavoring to issue as much clarity as it can about what it expects of licensees. And I certainly think that as of 2016, the regulated community was on notice that as an NRC licensee, if you want approval to do this, you have to go to the NRC rather than to agreement states.
My colleagues have any more questions? All right, we've kept you up a long time, Mr. Averback. Thank you.
Thank you.
All right, and Mr. Coley will give you 2 minutes of rebuttal. I think that's what you reserved.
Yes, thank you. So first to disposal, I'd like to draw attention to, this is in response to Judge Pillard's question. It's important that disposal is defined under the AEA itself. We cite this at page 9. The language is, the term disposal means the permanent isolation of low-level waste pursuant to the requirements established by the NRC under applicable laws or by an agreement state, if such isolation occurs in such agreement state. So there's no question, the regulation, of course, is consistent, but the statute itself defines disposal to be something.
What's the site for that?
Sure, it's the same statute. It's 42 USC 2021 little b sub 7.
Okay, thanks.
As my clock is rapidly, I'm gonna do a speed bullet here. With respect to your question, Judge Millett, about footnote 4 of the government's brief, those are not two exceptions. Both of those exceptions involve interstate arrangements. These are consistent with our view. It's no surprise that California, an agreement state, disposing in Ohio, not an agreement state. There were questions about that. So our beef here is the narrow one: intrastate disposal. And there's no question that intrastate disposal is governed by agreement state agreements. I want to correct something that, with due respect, I think the government misstated or overstated. 22,002 is not the regulatory framework here. Yes, there are many parts of Part 20, of course, that govern reactors, of course. But low-level land disposal is not one of them. Instead, it is 150.10. 150.10 says if you are in an agreement state and the NRC has consummated an agreement, again, a robust process, you can dispose pursuant to state approval only.
But only if you have quantities not sufficient to form a critical mass, and the commission says that's not what we're talking about here.
No, no, it's definitely what we're talking about here. Critical mass, the NRC critical mass. This is serious stuff, hot stuff. This is not left to the states. Look, the NRC doesn't have to give the states permission to regulate disposal sites. The states already have that. What they're disavowing is regulatory authority over low-level waste disposal. By definition, that's not critical mass. We're talking about protective clothing and soil and sediment and algae. It's not. This is as in the scheme of things, this is not at the core of NRC's jurisdiction and never has been. With the court's permission, I'd just like to kind of sum up. So there's a right-hand, left-hand problem here, and I don't want to bash on the NRC. It's a good commission. The agency, generally speaking, the industry has a good relationship with it, but they're proceeding not in a coordinated way. It's not just the 2009 guidelines. On the agency's website today, it says we disavow regulatory jurisdiction pursuant to state agreements. That's what it says today. So there's just a lack of coordination going on, within the agency, and industry's confused. The AEA is the relevant standard here. It says if you're going to claw back, if you're going to reclaim, you do so through process. And something that is titled a summary summarizing something that's titled a clarification, all of which on the substance speaks to interstate arrangements, and we have no dispute. That is not good enough under the AEA or the APA or the backbit rule.
But let me ask you, I'm having a little bit of a trouble grasping where
Okay.
the disagreement is, in the sense that Mr. Auerbach says we're not talking about putting it in the ground. You're saying we're only talking about putting it in the ground. Do you disagree that the commission can retain regulatory jurisdiction to look at and sign off on how the NRC licensees plan to package, to transport, and choose which authorized facility they're sending stuff to in the case of an alternate site that the state will sign off on? They just want to know about, because the alternate site is by its nature more ad hoc. They want to know, what did the state sign off on? They're not going to second guess it, but they just want to know.
So I want to make sure I'm tracking the court's question. So transportation, packaging, yes, there's no disagreement. The alternate site, it's not, I mean, in the real world, what we're talking about is municipal sites, RCRA sites, right? Sort of, right. So it's, I don't believe the government is arguing in this case. They just want to know. They are saying we have reclaimed authority over the disposal, over disposal, because they have already ceded to the states. Discontinues is not only the word of the regs, it's the word of the statute. They have already ceded regulatory authority over dumping in the hole to the states. So my client is unfamiliar with this distinction between disposal and disposal procedure, and the government's brief, with due respect, it doesn't provide citations for that distinction. So I don't know what, I can't speak to what that might mean, but we don't agree to your question that the NRC just wants to know or has authority over, what I'm going to call turning the shovel over, and they have given that authority up, again, only in agreement state, situations, of course, because they have decided that state law, state regulations, often promulgated in connection with the state agreement, are good enough. And there's no reason to think they are not. And the NRC is not arguing that they're not. Have I been responsive?
Yeah, I'm a little bit confused about, I have to say, what the commission is claiming and what it's not claiming with respect to what goes on with respect to what's anticipated to go on at the dump.
We share that uncertainty.
Right. Are there any further questions? All right. Thank you to both counsel. We kept you both way over your time, and we had lots of questions and needed a lot of information. So we're grateful to both of you for your assistance. The case is submitted.
Thank the court.
This honorable court is now adjourned until Friday, April 9th at 9:30 a.m.